So Ken, before we get started talking about the Chancery Court's landmark opinion in Caremark, I want to get a little bit of background on your position at Morris Nichols, who you were representing, where you were in the firm at that time.
Sure. So the case was 1996, I believe. I had joined the firm in 1981. I was a partner in 1989, so I was a relatively young partner, but a couple of years under my belt as partner. And it was a time when I was beginning to have my own clients and develop my own practice.
So do you remember when the call came in, how it came in, where it came from? How did you get involved?
I don't. Probably at that time it probably came through somebody else. Being a young partner, it was probably something that came from Lou Black or Gil Sparks or somebody like that, but I don't remember.
But you were lead on the case.
I was lead on the case.
So that must have been pretty exciting. Now, when the case first came in, was this a case that you recognized right off the bat was unique, or was it just another case that was similar to any other derivative case that you had on your docket?
A little of each. The company had been found to have engaged in some pretty serious wrongdoing. It pled guilty to a criminal count. It paid a lot of money. $325 million, I think it was. It's a lot of money now. It was a lot more money then. So it was, we knew that it was a significant issue for the company. And when you're in that situation, there's two sides to every story. But it's a pretty big indicator that something was amiss. Sometimes there's an innocent explanation. Sometimes it's less innocent, but it was certainly a big headline number.
Mm-hmm. And do you remember who was representing the plaintiffs?
Joe Rosenthal locally,
Mm-hmm.
And then he had some outside counsel, I think Goodkind Labaton at the time, and Loie Dannenberg.
Mm-hmm. And who was leading the charge for the plaintiffs? Was it mostly Joe Rosenthal, or was Labaton also involved?
I think it was, locally and on the procedural fronts here, I think Joe was handling most of that. But I think talking about the substance and the negotiations that led to the settlement, I believe that was primarily the Labaton folks.
Got it. And anything about that particular firm that influenced your strategy, your defense strategy, or?
No, they were a firm that it's a little bit different now. I guess you have firms like Stuart Grant and Joel Friedlander, who everybody knows is not afraid to try a case. They'll take them to trial. They seem to like taking them to trial. I think back then, most of the plaintiffs' firms, they would take a case to trial if they had to, but they did prefer to settle cases, and settlements were, almost all, you won't see a lot of reported decisions from plaintiffs' cases going to trial back then. It was not unheard of. There are certainly some, but there were a lot of preliminary injunctions, not that many trials.
Mm-hmm.
So they were somebody who, I think everybody knew that if you made a reasonable settlement offer, they'd be certainly willing to listen.
So put us into the context of 1995, 96, and that framework where there was at least some expectation that a settlement was likely, if not expected. Who makes the first bid? Is that the defense side? Is that, you're just speaking not in connection with Caremark, but just speaking generally? How do those discussions arise back in that era?
Yeah, usually it's the plaintiffs who's going to make the first bid, but that doesn't necessarily mean that they initiate the settlement discussions. A lot of times, the defendants might reach out and say, we're all going to incur a lot of cost. For you, plaintiff, once we've sunk the costs, the defense costs in, we're never getting them back. And at that point, we may as well go to trial. But, before we incur all that cost, maybe you guys want to make a settlement offer. Mm-hmm. Or maybe they would, the plaintiffs would do the approach. But, somebody's got to open that dialogue. And I don't think it's necessarily different from today. It's still who wants to be the first one to broach settlement. You know, sometimes it's perceived as a sign of weakness, so nobody wants to be the first. But if somebody doesn't say something about settlement, the talks never begin. So typically it's more often the plaintiffs, but not always.
Can you speak to the tenor of the discussions, in that time frame? I mean, where folks generally, and this is, broad generalizations, but generally pretty courteous, professional? Was there particular firms that were more aggressive than others? Any general observations that you would have from that era?
Yeah, I mean, back then, I guess there's a feeling that monopolies aren't a good thing, but sometimes they are a good thing. And Joe Rosenthal had maybe not a monopoly, but probably a 90% market share in doing the plaintiff's work. And he did a great service, not only to the plaintiff's bar, but to the defendant's bar and the state generally, because he was respected by everybody, particularly the plaintiff's bar. And when they would have disputes over, lead counsel and who's got which role, they would come to Joe and he would, sort of mediate those disputes, and they all got resolved. And so, we have all these lead counsel fights. Mm-hmm. We almost never had them back then because they would just all go to Joe, and they had so much respect for him that whatever he decided was the law, and that's how those things got resolved.
The dean of the plaintiff's bar.
Yeah, no, he absolutely was like the godfather, and for a guy named Rosenthal, you wouldn't think of him as the godfather, but he served that role in the plaintiff's bar.
That's incredible. So now I want to move into just kind of the context in which Caremark was operating at the time. So you mentioned that they had been under investigation by the Department of Health and Human Services, also the Department of Justice. Can you give us a little bit of a sense of what the nature of the allegations were at issue, and how Caremark had dealt with them generally?
Sure, and it's sort of interesting because so it was basically in the home infusion business where human growth hormone and other types of therapies would be infused at patients' homes. And the claims were that there were illegal kickbacks or payments for referrals, which under Medicare and Medicaid is impermissible. And so there were allegations that had happened on a sort of large scale. But what's interesting is Caremark was spun off from another company, and a lot of the conduct was pre-spin-off. So it was sort of on somebody else's watch. But Caremark was the successor, and they specifically, I believe, in the spin-off were assigned those liabilities, and so they were kind of stuck with them for better or worse. And it was their operations. I mean, it's not like, these were strangers who had done this. It was the same core team who had been at the predecessor at Baxter and then, became Caremark.
Mm-hmm. And so, post-spin, we've got a situation where the board is, named in a lawsuit in Delaware. Were they surprised at all to be named in a derivative suit, or at that point had they been so accustomed to being named as defendants or having the company named as defendant in a lawsuit that it was no great shakes?
Yeah, I don't think they were surprised. The company, obviously there was a pretty long on-ramp to this litigation. There was an investigation that spanned a few years. There were steps taken along the way to address some of the practices. There's a sort of series of cascading remedial steps that ultimately led up to the settlement with the government and the guilty plea, and pretty much simultaneously a settlement with the plaintiff. So as all those things are developing, I think the board understands that there's a pretty high likelihood that the other shoe is going to drop, and the other shoe being a derivative lawsuit.
Mm-hmm. Now, your recollection of that board, is it relatively modern public company board in the sense that it's composed of independent directors,
Yes.
non-management type?
Yeah, I mean, there were more management people, as I recall, on the board than you would see today. I mean, it's gotten to the point today where, a lot of times the only management member is the CEO, or sometimes you have the CEO and maybe the CFO or somebody like that, but the rest are outsiders. I think back then it was more common to have 2, 3, 4 members of management on the board. And I think probably for spun-off companies, that's probably more the case, although I haven't done a numerical examination, but that's sort of my sense.
Kind of the impression. And of the outsiders, any sense as to whether they were kind of active and engaged outsiders? I mean, I imagine that they had to be to some extent in dealing with all of the litigation.
Yeah, I think they were. I wasn't there before any of this happened, so I don't know how engaged they were, and I guess somebody could say, well, maybe if they were more engaged, things would have unfolded differently. I don't know. But once the possibility of a criminal investigation and a criminal indictment comes up, that sort of focuses people's attention. So they were definitely engaged, and as I said, there were a series of steps that were taken to essentially terminate some of these programs that were causing the problems, and eventually to get out of the home infusion business and ultimately to sell the business.
So this is, Caremark's one of these cases that Revlon, Unical, or now, MFW or Corin kind of stands for, a broad propositional law. And I think it's fair to say that it had a pretty significant impact on the development of the law, particularly governance and oversight. But Caremark, the company that you were representing, was operating essentially from a legal standpoint in a pre-Caremark italicized environment. What, if anything, were they doing in terms of putting in place, monitoring policies, procedures, et cetera, relative to their peers at the time, if you have any impressions or thoughts on that?
Yeah, I mean, what's interesting when you go back and reread the opinion is they had pretty robust systems in place, and it's why Chancellor Allen found that the claims were, I think he said, exceedingly weak, or words to that effect, because they did have an audit committee that was monitoring these types of things. They did get reports from both inside and outside counsel. They were fully aware of the legal regulations. They knew that some of the things that they were doing had been questioned and perhaps were questionable, but they got legal advice that they were on the right side of the law in terms of the programs that they were doing. And just to expand a little bit, I mean, it's a little bit, so you can't get money for referrals in Medicare and Medicaid. Outside of Medicare and Medicaid, there weren't regulations, so I guess you could, although some people might say it was unethical. But sort of where is the line? Like, obviously, if you say, okay, I'll pay you $500 for every patient you refer, that's pretty clearly a payment for referral. But if you're paying a doctor to give a seminar and that doctor refers patients, where is that on the spectrum?
At what point is it specifically a
Yeah, and if you're doing research grants, so, there's a whole range of activities that is sort of normal things that a company like Caremark might do, and where you've crossed the line is, at least was thought to be at that time a little bit of a gray area, a lot of a gray area. And they got legal advice and were told that they were in compliance with the law, and that while allegations had been made, that didn't mean the allegations were correct. And so what they were doing, they were told, was proper.
What are just your reaction as to how their systems stacked up against companies of similar size, nature of operations at that time.
Yeah.
And then maybe compare it to how things stack up today.
No, I think their systems were actually pretty robust, as I've said. I mean, we've seen a lot of instances where companies, have gotten into trouble. Obviously, we see the trauma. We see the ones where people pled guilty or in, some environmental problem or safety problem has happened. And so we tend to see the pathology. But a lot of times, the systems aren't as robust as, maybe with the benefit of hindsight you'd like them to be. These were pretty robust. I mean, the board was monitoring this, and they knew what was going on, and this isn't like I had no idea that this type of marketing was happening. We knew it was happening. We asked the questions, we got legal advice, we told it was proper, and I think their systems actually stack up pretty well compared to systems today.
Mm-hmm. So now getting down to some of the more granular legal issues, and I want to go back to kind of what the landscape of the common law looked like at that time. First and foremost, the nature of the claims, essentially breach of the duty of care.
Yes. They're good faith as well, I suppose, which I suppose is a brand of breach of duty of loyalty. But there was no allegation that any of the directors were making money from these alleged kickbacks. It's rather that there was a deliberate agreement to engage in wrongdoing and or a failure of a duty to monitor.
Mm-hmm. And the company had, in fact, included in its certificate of incorporation a provision under Section 102B7 of the DGCL to exculpate its directors.
As did everybody post Ben Gorman. Yes.
So
post 102B7.
So we're looking at a company that has a 102B7 exculpatory clause, and we're looking at essentially care claims, maybe with a good faith flavor to them. At that time, it was not as clear as it has now become that good faith was a component of the duty of loyalty. You still had cases talking about the triad of duties, right: care, good faith, and loyalty. But you're looking essentially at care claims, a company that has a 102B7 provision. These are outside directors. What did you perceive to be the strength of the plaintiff's claims? And it's a long-winded question, but I want to get to, in light of what the case law was like for that time, in terms of, and in particular, Graham versus Alice Chalmers.
Right.
And so if you could maybe just reflect on those points broadly. I just want to get your reaction at the time, how you were looking at this case.
Yeah, no, we thought they were very weak claims. Now, the problem is there's a lot of money at stake. Mm-hmm. So if you're saying the plaintiffs have a really small chance, a 5% or 10% chance, it's still a 5% chance at $300+ million. So that's a big check for somebody to write. And I don't recall what people's D&O insurance was in the particular case, but I'm guessing it wasn't $325 million. So, it's a small likelihood of a really, really catastrophic event. Mm-hmm. Plus, Caremark had really, by the time of the settlement, cleaned up its act. It had stopped the programs that were arguably compensating physicians. It actually stopped taking new home infusion customers, I think in 1993, 2 years before the settlement, and it eventually sold that whole division to a third party. So they were exiting the business, and my sense is that they just wanted to put this behind them. They wanted to clean it up, and they didn't want to be litigating this, even if they thought they had a very strong likelihood of prevailing. So a settlement made sense for them.
The law at the time was, refer to it as pretty director favorable.
It was very
in
director
the sense
favorable.
of, directors were not expected to, engage in corporate espionage
Right.
within
Well,
their own
I mean-
firms and ferret out wrongdoing.
Right. So Alice Chalmers used those terms and said, basically, unless there were red flags sort of waving in the director's face, they couldn't be liable, and they weren't required to, as you say, install espionage systems to ferret out wrongdoing if they had no suspicion that something was amiss. Sort of Chancellor Allen was very diplomatic in discussing that 1963 case, 30 some odd years later. He sort of said, well, they didn't really mean that, and they wouldn't have really said that today, and they probably wouldn't have even said it then. It's sort of unfortunate words, but they may have been unfortunate words, but there were a lot of defendants who wrote a lot of briefs saying, we don't have to put in systems to ferret out wrongdoing.
Exactly. And I guess it's just one question. In light of what the legal framework looked like, and I completely understand, the prospect of a massive liability certainly focused anyone's attention. But was there any tension within, the Caremark side of the V in terms of whether to settle, whether to, move forward with the litigation on the merits, or was it mostly everybody rowing in the same direction? Yeah,
I think everybody was rowing in the same direction. I wasn't involved in the guilty plea. Mm-hmm. My guess is that the guilty plea, was a lot more, if there was controversy, there may have been none, but if there was controversy, it was probably around the guilty plea and the terms of the guilty plea. The settlement was, putting in place some corporate therapeutics that were frankly already mostly in place and paying some attorney's fees, and I don't think that was a hard decision.
So the settlement was negotiated and reached fairly quickly. I think it was, around the middle of the year in 1995. It all wrapped up in about a month. Was that pretty common for settlements
I think it was
be reached that quickly?
Yeah, I think it was a little bit longer than that. I think it was sort of a May to July thing, but still, that's 2 months. It wasn't 6 months. We've seen this subsequently. Again, it tends to be, in my experience, then and today, it's really the settlement with the government. And, are we going to plead guilty to a felony count, to a misdemeanor count? It's just going to be a civil penalty. Are we talking about 100 million, 300 million? What are we talking about prospectively? Those things tend to be, very important, and you're talking about a lot of money at stake. I think once you've put that behind you and once you've sort of crossed that Rubicon, the settlement of the derivative case is not necessarily easy, but it's relatively smaller compared to the overall liability. And a lot of times you have securities cases as well that need to be resolved as part of the group. So it's not only the derivative case and the underlying wrongdoing. A lot of times there's a securities case that needs to be resolved, and you try to, once people wrap them all up, they want to wrap up everything.
Get it behind them. So as you kind of suggested, a lot of the consideration that the company provided in the settlement had the kind of ice in the winter nature to it. It was, we will agree to put in these therapeutic provisions. We'll have committees that monitor these things. We won't let anybody break the law, et cetera, et cetera. I mean, it really was not a huge concession. There was nothing that I would characterize as a huge concession on the part of the company. Do you remember whether there was anything that the plaintiffs had asked for that the company just said no way?
I don't remember. It wouldn't be uncommon, and again, I don't think this has changed. The way it typically works is when the plaintiffs want to settle, they'll give you a list of demands that's, sort of ludicrous.
Mm-hmm.
But it's like any negotiation, right? I mean, if you ask for the sun, the moon, the stars, and maybe you'll get a small planet somewhere. So I don't remember specifically, but I wouldn't be surprised if they had a list of 30 items that went from the sensible, all the way on to the absurd, and we said no to the absurd and yes to the sensible. It's typically how it works. I don't remember specifically in the Caremark case.
And so, now, did you have any thought that perhaps that wasn't enough, what the company was giving, to get the settlement approved, or any thoughts on that side?
No, we really didn't. This is where an area where the law has changed.
Mm-hmm.
I think that the seminal case, and it goes back to the Graham v. Alice Chalmers era, is Rome v. Archer. I think it was a 1964 case, so
Mm-hmm.
it's the same year, a year later. I hope that one has better legs than Alice Chalmers had, because Rome v. Archer says, look, we favor settlements, and they're good for society, and they're what we want. Now, disclosure-only settlements, that's a different subject for a different time, and obviously there have been abuses, but this was not a disclosure-only settlement. I think we all felt that these were not strong claims, that the settlement was very likely to be approved because there was real consideration. I mean, obviously, if there were some fantastic claim and, the board had never had reporting in place, and there was a real, what we now know as a Caremark claim, a viable Caremark claim, and we were settling it for, something that wasn't real, it would be a problem. But, it's funny. What was put in place was very good consideration.
Mm-hmm.
It was, an independent committee with outside directors that would function on these issues going forward, and 4 meetings a year and reports from management. That's all great corporate governance. The reason that it wasn't good consideration in the Caremark place, it already existed, but that's the exact reason why it was such a weak claim.
Yeah.
I mean, if none of that existed, you'd have a much stronger claim, but you could do the exact same settlement and say, well, this is a real benefit to the company because it had nothing before, and now, everything that's in this settlement is new. Very little was new in the settlement, but that's exactly why the claims were so weak.
Mm-hmm. At any point in the case, up until the time that you actually saw the opinion, did you have any inkling that this was going to become, a case that's synonymous with a legal proposition?
I wish I could take credit for any part of that, but the short answer is no. We the people on the defense side, we all thought this was just another settlement. It was going to get approved. Back then, I think there were opinions in most cases, so we figured there'd be an opinion, but we figured there'd be 5 or 10 pages talking about the background facts, and the claims were weak, and the settlement consideration is sufficient, and an award of attorney's fees, and that would be that. I don't think anybody on our side of the V had any inkling that this was going to be a landmark case.
Mm-hmm. So now the court finds that the consideration is not so robust, but also finds that the claims are incredibly weak, so the consideration matches the strength of the claims. Nevertheless, takes an opportunity to write an opinion that sends a very clear signal about the need for having monitoring, compliance systems in place. Any thought as to why the court, and this is pure speculation on your part, but why the court uses this particular case as a vehicle for that message?
Yeah, I think that it was something that was probably on Chancellor Allen's mind, but I think in particular, when you look back at it, I mean, I have my own theory, I've heard other theories, but Number one, I think he understood that Graham v. Alice-Chalmers was not really very good law, and that it's, sort of almost a little bit embarrassing for the state of Delaware, frankly, that, we corporate espionage to ferret out wrongdoing. I mean, that can't be the standard. So I think he wanted to fix that. I also think that you look at a case, and if you're a judge, how do you write the opinion in this case, knowing that you want to do something with Graham v. Alice-Chalmers? So you say, okay, that can't be the standard, but I can't just say that. I have to have a different standard. I have to propose something. You can't just tear it down. And plus, he's got to justify the settlement here. So if he says, look, Graham v. Alice-Chalmers, that's bad law, we shouldn't really do that, we have to have more robust systems, he's still got to justify the settlement in this case, and he's got to do that. I mean, I think he thought that the board here hadn't really done anything wrong, and I think anybody looking at this case today would say that, that, some unfortunate things happened, but if anything, perhaps they got some bad legal advice. But, what do we want boards to do? We want boards to consult with lawyers, to listen to their advice and follow their advice. And that's what this board did, inside and outside counsel. And they were aware, as I said, that there were some gray areas, but they were told they were on the right side of those areas. And by and large, they were. I mean, there were a couple of doctors. I mean, this was a nationwide program with, thousands, well, hundreds, maybe thousands of physicians, and certainly thousands of home infusion sites. And, when you look at what they actually got charged with, it's a doctor in Minnesota, a doctor in Ohio. It's, it's, you can make the argument that they were, by and large, on the right side of the line. And you can also say, well, really? Then why'd they pay $325 million? Fair question. My only point is they did what boards are supposed to do. So I think that the chancellor, in writing an opinion, wanted to say that, this board really didn't do anything wrong. And so he was, I think, looking for what is the right standard. If we're going to replace Alice-Chalmers, what are we going to replace it with? And he seized on the sentencing guidelines, which, I think was very clever on his part, and it's sort of typical of Bill Allen, because one of the things I've always admired about him is he sort of has this, he understands the particular case and the equities of a particular case, but he also sees where it fits into the entire framework of Delaware law and sort of societal values more generally. And so, it's obviously an opinion that stood the test of time and has served Delaware very well, and for good reason.
And now, did you recognize when you first read the opinion that it was going to have a long-term impact and that it did represent a fundamental shift, or was it, thank God my clients are out and the settlement's been approved?
No, we expected our clients to be out and the settlement to be approved. So that part, we always read opinions. You probably do in cases you're involved in. When there's an opinion, you turn to the back and you see what the result is, and then you turn to the front and see why. And so we turned to the back and we saw approved, and that was, not unexpected. And there were no objectors, I don't think, so that's also an unobjected settlement is probably going to be approved in any event. And then, reading it, yes, I think we all were like, wow, this is great. Why didn't we think of this? Sort of that type of reaction. But yeah, I think we knew that this was an important decision as soon as we read it. And it's obviously something that the chancellor thought about greatly. It may have been something on his mind before he even wrote the opinion. I suspect it was. But it was certainly, fully formed and very, very well thought out, and we knew that it was going to be an important decision going forward.
So corporate lawyers are great mimics, whether they're litigators, transactional guys, advisory folks. Did you see an uptick in Caremark claims after this?
I don't think so. Alice Chalmers was a somewhat impossible standard for the plaintiff's bar. But, Caremark still sets the bar pretty high for plaintiffs to overcome the protections of Caremark. I mean, I think the court, I think Chancellor Allen says it, that these are going to be difficult claims to establish. I can't remember the exact words he uses, but it's going to be the rare case, and I think subsequently cases have said Caremark claims are among the hardest to plead and prove, and that's proved to be the case. But there certainly have been Caremark claims that have survived motions to dismiss, and I'm sure there'll be more.
In the immediate aftermath, did you get any calls from general counsels, lead directors, chairmen saying, "Hey, we need to get you in here to guide us as to what types of policies, procedures we should have in place"?
Yeah, I think there probably were some. I don't think there was a groundswell, but and I, not somebody who, A, fairly young, and B, somebody not generally doing corporate advisory work. So I didn't get those calls, but what I did get is, when there were derivative suits, sort of having your name on the Caremark opinion was not a bad thing. Right.
That's exactly right. What was your client's reaction? Were they just happy to be done with it?
Yeah, and again, I don't think they expected anything different. This was a pretty solid settlement. As I said, we thought we had very good defenses, so I don't think there was a great deal of concern that somehow the settlement was not going to get approved. There were no objectors, and so that also leads to an expectation that it's going to be approved. So I think that... No second guessing, the court said it was so weak we should have just gone forward? No, I don't think so at all. And I don't remember the details, but my guess is that the attorney's fees were not paid by the individual defendants, but were rather paid by a D&O insurer or somebody. Mm-hmm. That would be my guess as well. Any other observations about your time or experience in this case? Anything you want to add? No, I think you've done a good job of covering it and bringing out the high points. Very good. Well, I appreciate the time, Ken. Okay, thanks so much.
Thank you.